5, 4, 3, 2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Clerk. Before we begin, are there any preliminary matters, Mr. Clerk?
I know, Your Honor.
And will you please call the case, please?
Tennessee Farmers Mutual Insurance Company versus John A. Simmons et al.
It's my understanding we only have one party that will be presenting the argument today, and that's for the appellant.
Yes, Your Honor.
Okay. And Ms. Hayes, that is,
Yes.
Are you prepared to present your argument for the appellant?
Yes, I am, Your Honor.
Okay. I want to ask you if you reserve any time for rebuttal, since that will not be an intervening argument, but I'll let you go ahead and present your case.
Very well. May it please the court, my name is Janet Hayes, and I appreciate you entertaining my argument even in the absence of an adversary today. As the court is aware, this is a declaratory judgment action. This is a case where Tennessee farmers should have been granted summary judgment at the trial court because the only fact that was disputed at the trial court was created by an inconsistency in the defendant's own testimony. Had the trial court applied the cancellation rule that exists and is embodied in Tennessee law, then the testimony would have canceled out and there would have been no dispute as to fact, and the case would have been decided on summary judgment. So of course I would like to address the cancellation rule, but before I get to that, I think it would be helpful to go back and review what happened in this case. The defendant, Mr. Simmons, made a claim on his personal automobile insurance policy. Now, Mr. Simmons also had a business. He was a sole proprietor in a business known as Simmons Diesel. The business was a separate business. It had a separate building. It had a business license. There was no garage policy or commercial policy related to that business. In May of 2017, Mr. Jeremy Shipley brought his Ford F-250 pickup truck to Simmons Diesel for the purpose of having it repaired. He specifically asked two things. He said his oil pressure was dropping, and he asked that Simmons Diesel make the truck ready as he needed to haul a trailer the next week. So he left his truck there for repairs, and 3 days later, Mr. Simmons was involved in an accident while driving the truck. He was sued as a result of that accident, and he made a claim under the Tennessee Farmers Policy, which was his personal automobile insurance policy. Now, the personal policy that he carried had a very specific business exclusion in the policy. It's not unlike many business exclusions that exist in personal policies. It specifically provided that there was no coverage for any person or entity, and I quote, while employed or otherwise engaged in the business or occupation of repairing or servicing vehicles, and goes on to say, including road testing and delivery. So the policy very specifically excluded coverage while a vehicle was being road tested. Now, in light of that exclusion, Tennessee Farmers did an examination under oath of Mr. Simmons. And in the examination under oath, of course, they asked very specifically questions about what the purpose of his travel was. In his examination under oath, he said that he was road testing the vehicle. And I can read the specific testimony is on page 72 of the record. He was asked, as I understand it, at the time you were driving the vehicle on Friday, June 2nd, at the request of Mr. Shipley, you were test driving it or road testing it to see if there were any other problems that might need to be addressed before he could halt his trailer the next week. Right. Mr. Simmons answered, yeah, he just didn't want the oil pressure dropping. In light of Mr. Simmons' unequivocal testimony that he was road testing the vehicle, Tennessee Farmers filed a declaratory judgment action and ultimately filed a motion for summary judgment. It was not until that stage in the proceedings that Mr. Simmons submitted an affidavit. And in his affidavit, he directly contradicted his EUO testimony. In the affidavit, he did not say he was road testing the vehicle or test driving it. He said he had been given permission by Mr. Shipley to drive the vehicle and was driving it on a personal errand at the time of the accident.
Ms. Hayes, let me interrupt you really quick. I haven't
Sure.
looked back at specifically at his affidavit and also at his trial testimony. But in the affidavit and in the trial testimony, what does he say? Does he say only that he was, I think he said he was taking his kid to soccer practice or something like that when he changed it. Does he say at all that he was also test driving it, or does he just say, just changed it wholesale to not that I'm road testing it, but now I'm just doing an errand, taking my kid to soccer?
He completely changed it in the affidavit.
Okay.
In his EUO testimony, the question he was asked used the words road testing or test driving. And he said, yes, he was road testing and test driving it. Nothing was mentioned in his EUO testimony about an errand or personal use. In his affidavit, and in his trial testimony that came later, he said that Mr. Shipley had told him he could use the truck for whatever he wanted. So he was doing personal errands and had been to pick up something, I think at a Napa Auto Parts, and was on his way to his daughter's soccer. He did not in his affidavit say anything about road testing or test driving. In fact, he says he did not need to test drive the vehicle, that wasn't necessary. At the trial court level on summary judgment, of course, Tennessee Farmers asked for summary judgment, and they asked that the court apply the cancellation rule. And the cancellation rule, as this court has articulated, and I would specifically point to the case of Lynch v. Portis, as that sort of explains the cancellation rule. And it says that if a witness offers testimony that is directly contradictory, the testimony should cancel out. So Tennessee Farmers' obvious position is his affidavit cancels out his prior testimony. So there's no question of fact. But instead of applying the cancellation rule in that way, the trial court refused to grant summary judgment. In Lynch v. Portis, the appellate court has said, and I want to quote this because I think it's important, has said the cancellation rule raises neither a question of credibility nor of weight of the evidence. But the trial court, in denying summary judgment, said this simply has to do with, quote, assessing the credibility of the witness at trial. So the trial court just didn't apply it and said that the applicable law said this is a question of credibility of the witness, when under the cancellation rule, it's really not. So that error.
Let me ask you this too, Ms. Hayes. As a practical matter, when we say that the contradictory testimony cancels each other out, at the summary judgment stage, you've got sworn testimony in an EUO, and then you've got sworn testimony in affidavit. If you were to apply the cancellation rule there, it means that neither of the testimonies comes in or is considered.
Right.
Is that okay? And then let's say if we have it at trial, we went ahead and went to trial, and he gets up on the stand and he says, I was running an errand, and that's contradictory to what he said in his EUO. Is it then the trial judge's obligation to say what does the trial judge do at that point? Or is it supposed to be excluded before it even comes in?
Well, I would ask that it be excluded before that it comes in, but I can obviously there's going to be scenarios where that can't happen, and I think the trial judge would then instruct the jury that the testimony cancels out, that
they're not to
that
consider
testimony is not to be considered.
either one of those scenarios, or either one of those pieces of testimony, I guess.
Correct.
Okay.
And importantly, had the testimony canceled out at the summary judgment phase, there was the affidavits that Tennessee Farmers had introduced based on their investigation, and there was the obvious fact that this F-250 truck and the owner of the truck's testimony that he dropped it off for repairs at Simmons Diesel. He was a prior customer of Simmons Diesel. There was no testimony at summary judgment about the errand other than this contradictory affidavit that was introduced. Now, at trial, I think the error is exacerbated. The error was made at summary judgment, but at trial, Mr. Simmons was allowed to sit on the stand in front of the jury and offer his testimony to the jury that he was on a personal errand. Now, of course, Tennessee Farmers was allowed to use the prior testimony to attack his credibility, but that certainly doesn't have the same impact. Tennessee Farmers challenged this on a motion for a directed verdict. They challenged it again in post-trial motions. And I think it's worth noting in the post-trial motions, the trial court judge, when we specifically highlighted the fact that there's case law that says you can't use this to impeach the credibility of a witness, it's a cancellation rule. The trial court judge then recognized that, and then on the post-trial motion said, well, under the cancellation rule, you don't have to apply it, and this is true. Under Lynch v. Portis, you do not have to apply the cancellation rule if the testimony has been explained or corroborated. Now, everyone agrees the testimony was never explained. As we sit here today, there's never been an explanation for why he has testified two different ways. But the trial judge said, well, I'm going to find that the testimony was corroborated, but it was not. The only other testimony that was introduced at trial was the testimony of Mr. Shipley, the owner of the truck. And the owner of the truck said that he did not give Mr. Simmons permission to use the vehicle for personal errands. He was very clear in his testimony. Again, I would direct you to page 72 of the record. And he was asked, did you ever, or the question was, but you never talked to him, did you, about using it for personal errands? He said no. The next phone call I had was Friday morning when the truck was wrecked. And there's no question Mr. Shipley did not corroborate it. So when I look at the trial court's opinion as to what was the corroborating evidence, the only thing the trial judge points to as supposed corroborating evidence, the trial judge says, well, the driveway was long, so he could have been test driving it on the driveway. He wouldn't have needed to take it out. Well, that's not corroborating the purpose of travel, saying that someone's driveway is long. He also says it's corroborated by the fact that Mr. Shipley and Mr. Simmons were personal friends or acquaintances prior to this accident. That is true, but they also had a prior business relationship. The evidence introduced shows that Mr. Shipley was a customer of Simmons Diesel, had previously paid for repairs at Simmons Diesel, and had his F-250 hauled on a flatbed to Simmons Diesel to have a repair made. So I don't think the fact that they were personal friends in any way corroborates, again, the purpose of his travel. The only other thing I could find the trial judge points to as supposed corroborating evidence is the fact that the repair was made one day and this test drive occurred a couple of days later. Again, that may be true, but that's not corroborating the purpose of travel. And I'd like to point out that all of the supposed corroborating evidence comes from the person who gave the inconsistent testimony to begin with. And the bottom line is I think there simply is no corroborating evidence.
What about the testimony, or was the testimony as to what errand he was on at the time?
His testimony was that he had gone to, I believe it was a Napa Auto Parts, to pick something up and was on his way to his daughter's soccer practice. That's his subsequent testimony.
Okay.
In the brief time I have remaining, I'll simply mention another issue that came from the trial, and that's with regard to comparative fault of the agent. Comparative fault of the agent was not pled. And so when Mr. Simmons' counsel at the early stages of the trial evidenced an intent to rely on that defense, an objection was raised and the court ruled that evidence of comparative fault of the agent was not admissible. However, the trial judge refused to give a limiting instruction and then later allowed testimony, specifically allowed testimony about what's your agent's name, whether the agent ever told him he needed a commercial policy, whether Farm Bureau issued commercial policies, whether Simmons relied on the agent to make decisions. Now the trial judge says, well, Tennessee Farmers opened the door. The alleged question opening the door was simply the question to Mr. Simmons, do you know what a garage policy is? So certainly we would submit that a question, do you know what a garage policy is, does not open the door to who is your agent? Did your agent ever have these conversations? Did you rely on your agent? And a whole line of questioning regarding comparative fault. Obviously, Tennessee Farmers didn't have a chance to call the agent as a witness or have any proof at trial to deal with a comparative fault defense. In my last minute, I would simply point out, we're not saying that Mr. Simmons was trying to scam Tennessee Farmers at all. We certainly understand this could have been an honest mistake. He simply didn't have the coverage on his business. And I understand a sympathy with that, but there are two very important reasons why we can't find in his favor just because he bought the wrong insurance policy. First, it would be a bad policy. It's not fair to those people who pay premiums to get the proper coverage, and it's not fair to the insurance companies who accept lower premiums for personal policies. This court said in Aetna versus Martinez, and I quote, "It would be grossly unfair to the insurer to hold that an insured engaged in the automobile business could take out a policy on his privately owned and operated car and then on the basis of the same small premium claim protection for any and all unowned automobiles used in such business. Policies of that nature providing general coverage for businesses carry a much higher premium." Also, I'd simply like to point out, accepting or not applying the cancellation rule basically erodes the whole concept of summary judgment. If a party can simply contradict themselves in two different sworn testimonies, then a party can always create an issue of fact, and there will never be summary judgments. So to uphold this decision of the trial court completely corrupts the concept of summary judgment as we know it.
Thank you, Ms.
My
Hayes.
time is out.
Thank you for your presentation. Your case has now been submitted to the court, and you will receive our opinion and ruling within a due period of time. Thank you very much.
Well, thank you, Your Honor.
You may be excused.
This honorable court is now in recess until 3:30 p.m.
Thank you. Mhm.